Hey guys, Aaron Dorr here with the Missouri Firearms Coalition. Join the day with special guest Attorney General Andrew Bailey to talk about the recent lower court opinion on the Second Amendment Preservation Act. Mr. AG, between going after Kim Gardner for not doing her job and SAPA, you're a very busy guy. Thank you for your time. We appreciate it very much.
Hey, thanks for having me on. Appreciate the chance to talk about this vital piece of legislation and the constitutional implications that are at play here.
Yeah, we appreciate that, again, very much your time. I mean, SAPA is kind of a foundational idea here in Missouri and across the country. And despite what we're hearing in the media today, as of course you and I know, all SAPA does is says that here in Missouri, the Missouri legislature decides how Missouri cops can be used, that if they want to assist the feds, they can. But in this case, when it comes to gun control and enforcing federal gun control laws, Missouri SAPA law says, no, our cops work for us. And of course, that was challenged, as we all expected, by the DOJ. And last week, Judge Wimes from Kansas City came out and said that this law is unconstitutional. So tons of gun owners in Missouri, and of course across the country, have some questions. We have filtered questions from our members. The big one right out of the gate is, will you be appealing this decision from Judge Wimes?
Yeah, absolutely. Look, this is about protecting the constitutional rights of the people of the state of Missouri for me. And so we're absolutely going to appeal. We've already filed our notice of appeal. We've asked the trial court to stay his order. He has granted that in a limited capacity. So his order is stayed pending what the Eighth Circuit decides to do on appeal. So there's really two things going on at the Eighth Circuit right now simultaneously. Number one, there's the issue of whether or not the district court's order should be stayed. In other words, is the law in effect or is it not? And we're going to brief that to the Eighth Circuit Court of Appeals. Our brief is due early next week on Monday. We anticipate getting an answer within the next 14 to 21 days on whether or not a stay should be in place as the appeal goes forward. And we feel very strongly that it should be, that the district court's orders should be stayed, that the law should remain in effect while we go through the appeal process. But then there's the merits of the case itself. We feel very strongly that we're in a better place at the Eighth Circuit Court of Appeals. We'll get a 3-judge panel assigned to hear the appeal, and we'll brief that. I think briefings due in early May, so we've got ample time to get a good brief together. We're working with partners across other lines and other states, experts on these constitutional matters, and the text, history, and tradition is going to matter as we make our arguments. And then we anticipate that within the next year, we'll get a ruling from the court. Now, if we don't like the answer we get from the 3-judge panel, then we'll likely appeal en banc. And what that means is we'll ask the entire Eighth Circuit as a group to hear the appeal. And so we've got several different remedies available to us, procedural mechanisms we can use to make sure we get a good result and protect the Constitution.
Well, that's great. And you, of course, answered about 4 of my questions in one big answer. So I'm going to kind of dissect that just a little bit. So for those who aren't aware of this process, for the federal court process, you have the district court judge in Kansas City who issued last week's opinion. And then, am I correct, you had the circuit court process to appeal those decisions. And then from there, it goes to the Supreme Court. Do I have that correct, first of all?
Right. District court, circuit court of appeals, Supreme Court.
Okay, and so this lower court opinion, when you appeal this is going to be appealed to who? How does that process work exactly?
We appeal, because of where Missouri lies in the federal judiciary, we appeal to the Eighth Circuit Court of Appeals. And so the Eighth Circuit Court of Appeals will administratively assign a 3-judge panel. And that's just how the appellate court functions. You get a 3-judge panel to review each case. And then if you don't like the answer, you can ask for a rehearing en banc, which means the entire court would review the matter. But we feel confident at the Eighth Circuit. We think we'll get a good result there.
Excellent. Now, you mentioned a stay in this case. I want to make sure I put this in non-legal terms for our members who are watching. A stay means that right now, Judge Wimes said, okay, SAPA is unconstitutional, but it's going to remain in effect pending the outcome of your brief to ask the Eighth Circuit for a long-term stay pending the outcome of your ultimate appeal. Is that correct?
Yeah, that's exactly right. And so again, we're litigating 2 things at once here. Right now, we're litigating whether or not the stay should remain in place and the law should remain on the books while we appeal through the Eighth Circuit Court of Appeals process. We feel very strongly that that's the right legal answer. And Judge Wimes certainly recognized that as well by granting the stay pending the motion for stay on appeal. But then we're also litigating the merits of the case, and that'll take a little bit longer. We anticipate an answer on the stay from the Eighth Circuit within the next 14 to 21 days. But the briefing on the merits will probably be later this summer.
So best guess later this summer, you're saying, for the actual appeal on the underlying constitutionality of SAPA. I know no one can forecast turnaround times from the circuit court, but what's your gut tell you as far as a response time or kind of an answer to the merits-based appeal? Is there any way to guess something like that?
Yeah, I mean, I can give a rough outline of what I think will happen, but like you said, it's subject to the parties and how much time they need and to the 3-judge panel and the decisions they make. But I anticipate that we'll have our brief due sometime in May. There will be a response due shortly thereafter, and then we'll head to likely head to oral argument at the 8th Circuit Court of Appeals sometime this summer, and hopefully, maybe before the end of the year, maybe early 2024, we'll get an answer from the 8th Circuit Court of Appeals.
Okay, well, that's an actual number we can kind of hang our hats on. We appreciate that. Getting away from some of the process questions, more to some of the larger macro stuff. It's amazing to our team and to our members who read this opinion. Judge Wimes never even mentioned the anti-commandeering doctrine, which is a foundational element to SAPA. The idea that the feds cannot seize Missouri resources, in this case, our law enforcement officers, to enforce federal gun control. That was never even mentioned in the brief. He didn't mention the Prigg case from 1842 that said that the states could not be required to return runaway slaves. And he hardly mentioned the Prinz case, which is perhaps one of the most landmark cases of all, 97's case about how the state or the feds cannot order sheriffs to enforce federal background checks. Does that make you hopeful for the merits of the appeal? He didn't mention perhaps the most foundational elements of SAPA law?
Yeah, look, when I say protect the constitutional rights of the state of Missouri, it means our individual right to keep and bear arms, but it also means our structural rights to have a system of dual sovereignty between the states and federal government as envisioned by the founders and codified in the 10th Amendment. So this is as much about the 10th Amendment as it is the Second Amendment. And obviously the Prince case is a seminal case on interpreting the 10th Amendment and the role that the federal government plays in relation to states in this system of dual sovereignty. And I would point to Federalist number 39 as really the best articulation out there as the original understanding of the limited role the federal government's supposed to play and the more expansive role that the states are supposed to play. And specifically, it says that the rights of the states, the sovereignty of the states are inviolable, and that the state has plenary authority over anything not specifically given to that authority not given to the federal government. And so that the 10th Amendment has to mean something. Right. And I believe that that SAPA is really just an expression of the state's authority under the 10th Amendment.
When I met in your office with you about a month ago in preparation for the outcome we expected to have here from Kansas City, you guys mentioned something to me about how the name of the lawsuit from the federal government meant something to you guys. And it's because it's United States of America versus state of Missouri. And you guys, that meant a lot in terms of how this is being perceived by the DOJ. What did that tell you? What does that mean? And I guess when you mentioned the 10th Amendment and these state sovereignty issues, is that why we see such an aggressive titling in this lawsuit?
Yeah, look, Biden's DOJ is out to get the state of Missouri. That's what this lawsuit is about, and we're going to defend it. The General Assembly has spoken. And under our system of separate but equal authority, I'm in the executive branch. I enforce the laws given to me by the General Assembly. The General Assembly has enacted, the people's will have been expressed by their elected representatives in the General Assembly. And so we're going to defend this law. And it is about that system of dual federalism. And certainly we're excited to be taking that fight to the courtrooms in the state of the United States of America. But I'll say this it's rare. It's rare that the United States comes after states individually. That happened in Texas when Texas passed some abortion restrictions that Joe Biden didn't like. It happened in Georgia with Georgia's election law that the Department of Justice didn't like. So look, this is absolutely an attack by Biden's DOJ against a state law duly enacted by our elected representatives, and we're going to fight back.
So in that context, then, when you guys win, and I'm very optimistic you guys are going to crush the DOJ in the 8th Circuit, when you guys win, or God forbid this case, we lose in the 8th Circuit, then, of course, either side can appeal this to the Supreme Court. That's one part of this question. If we lose to the 8th, will you appeal this matter all the way to the Supreme Court?
Yeah, absolutely. We're gonna fight this all the way to the highest court in the land if we have to. The Second Amendment and the 10th Amendment have to mean something, and the founders certainly understood that those rights are given to us by God, not man, and that the Constitution sets a floor, not a ceiling for those rights. And so, if the General Assembly wants to expand upon those rights, they have the authority to do that, and we're going to defend it.
So that part B to that question is, if you're Merrick Garland right now and you're in that radical leftist war room right now in the DOJ, if you lose in the 8th, what do you do? Because if there was ever a time in my lifetime to have a gun case go to the Supreme Court, it's right now. We had a 6-3 opinion on the Bruin decision from last year. This is this is the best time perhaps in our lifetime to have a gun case go forward. Do you believe DOJ will appeal this if they lose in the 8th?
It's hard to predict. I certainly feel like they've come in hot enough on this issue that they also intend to take it all the way to the highest court in the nation if they have to. So I would not, we plan for the worst and hope for the best.
Yeah.
We anticipate a good result at the 8th Circuit. And if that happens and we get the win at the 8th Circuit, then we'll be prepared to defend it all the way at the United States Supreme Court. And I'll be proud to sit at counsel table at the United States Supreme Court and represent the people of the state of Missouri and defend our constitutional liberties.
Absolutely. Absolutely. So as you know, our organization has a lot of sister organizations in state capitals across the country. We have some in red states, some in blue states, but I can tell you, of course, that all of Red America is awakening. If they haven't already been aware of Missouri's SAPA law and all the 10th Amendment aspects of it, they're now getting a quick crash course in this. Are you hearing from other red state attorney general about this issue? And are they kind of offering assistance, or what are you hearing from your colleagues across Red America about the impact of SAPA and their thoughts on it?
Well, from a global perspective, we've seen the states are the vanguard in the fight against the rise of the federal administrative state, and state attorneys general are the tip of the spear in that fight. And so we coordinate on any number of issues in relation to this dual system of sovereignty between the state and federal government. And this is just a flashpoint in that broader fight. And so this one has to do with the Second Amendment, but we see it in other contexts as well. And what we see is that President Biden is now pushing a radical left-wing agenda through unelected bureaucrats across a spectrum of federal agencies because he can't get those bills passed through Congress. Right. And so we've got to stay alert. We've got to stay active in the space, and we've got to join together where we can because there's strength in numbers. And certainly we're proud to do that. I know this is a closely watched case. We hope that we'll get the right result here. We feel confident that we will, and we'll keep up the good fight with anybody that wants to partner with us in that endeavor.
No, that sounds perfect to us. Last question I've got for you. We have a lot of states that have versions of SAPA on the books, but only Missouri has, we call kind of the gold standard right now, where we have the civil penalties in there because Missourians are well aware of the fact that we have these mega blue cities in our otherwise red state, and without some way to enforce compliance, SAPA law would have been just tread right over. So that's why when we were in oral arguments in Kansas City, for example, the judge asked the United States, are there other states where you guys are trying to shut down SAPA law? And the DOJ said no. Missouri is, in other words, this is my words, not theirs. Missouri has the best of the best because we have civil penalties. Have you seen in the last 6 months any other states coming under fire from the DOJ over SAPA law, or is Missouri still the only one being challenged?
Well, I think right now we're the tip of the spear in this fight. I really do think that. And again, we're proud to be leading this effort. I anticipate that what happens in this case will dictate policy in a lot of other places and a lot of other state houses across the country as people watch and learn about the importance of not only the Second Amendment, but the 10th Amendment and that dual system of sovereignty. And so as we reinvigorate, as we breathe new life into that, that was first acknowledged in the Prince decision and that we want to carry on today and breathe more life into that, I think that'll motivate other states to act accordingly. And so excited to be the tip of the spear in the fight.
Absolutely. Again, thank you so much for your time today, sir. I know you're very busy right now. There's a lot going on. The update's very helpful for our members. We'll keep fighting on the outside to put pressure on the GA to keep the law intact and help you guys on the outside any way we can with amicus briefs. And thank you so much for all of your fighting to help protect Missouri's SAPA law.
Hey, thank you for everything you do. Good luck to you as well. And we'll look forward to talking again soon.
You bet. Take care.